Welcome to the Settle Law Clinics podcast.
So there are instances where parents disinherit their children because they might feel, well, this particular child feels entitled and I've done all I can for this child or all I should for this child in my lifetime. People get this misconception that you only put your house in order when something is about to happen. No. Think of estate planning as organizing your life for time. It's more like taking pots to ensure that the things you have acquired in your lifetime is well catered for. People think is when you actually do the will. That is when you have started estate planning. No. It starts from how well you safeguard your assets. It's not for the old alone. It's not about the age. It's not how long, but how well. Success is not measured in a lifetime. Success is measured in phases. A will is a legal instrument that contains the desires, the instructions and the directives of a person in his lifetime. The people witnessing your will cannot be beneficiaries to your will because your will is supposed to be a secret. If the witness to your will is a beneficiary to your will, then that's a ground for invalidity. In real life, wills are not read in your lawyer's office. The person dies, your will is not read in your living room. Your wills will be read at the probate registry.
Hello and welcome. My name is Adini Kyoyarikwa and I'm your host. This episode is a continuation of our conversation on estate planning. Before we start, can you do me a favor? Click the subscribe button and turn on your notification. That way you'll be the first to know when we drop the next episode, and at the same time you'll be helping us grow this podcast channel to be able to reach more people who can also benefit from the information shared. Also, don't forget to like, share and comment on this content. It helps us know which topics are beneficial to you, and we can continue to create more content like this. Thank you so much. So let's get into today's conversation.
You made mention of two things when we're talking. You kept mentioning will and codicil. So can we talk about that?
Okay.
What is a will? What is a codicil? And I want to add a third one to it. What is a trust? Because there's this, general thing we see trust. What are they?
Okay. I'll start with a will. A will is a will is a legal instrument in which it's like okay, let me put it in layman's terminology, or in layman's terms. It's a document that contains the wishes or the desires and instructions. So a will is like a document or a legal instrument that contains the desires, the instructions and the directives of a person in his lifetime. We normally say that a will is ambulatory. That means it takes effect upon the death of a person.
So the person who wrote it.
The person who wrote it. Now, by who wrote it, it doesn't mean that the person practically wrote it with his hand. You can write your will yourself. You can also engage service of a lawyer to write your will for you. Now, the reason why it's better to engage a lawyer to write your will is that there are lots of aspects that you may not be able to cover if you do them yourself. It's just like most people now go ahead to do draft legal agreements for themselves. Contracts, yes, for themselves. And they'll use AI, draft contracts for themselves and sign. And by the time there are issues that come out of that contract, you now go back to a lawyer to resolve those issues because you did not avert your mind to the basics that needs to be in place in that agreement that were not covered. So those are some of the things too that you see when people draft their will by themselves. Now that does not mean that you cannot bring a draft of what you have written down as what you wish or what you desire to be in your will. Your will is like a list of instructions that you want your loved ones or people around you to do concerning your assets, the people you love, and everything you feel you own. It's you still talking after the person is dead, giving instructions, and then it's the legal way of enforcing your wishes and directives after a person is gone. So in general, in will, is a set of instructions. I'm trying to put it in layman's terms that anybody can understand. It's your instruction book, like your legal book, that this is what I want my people to do for me. This is what I want to be done to my wife. This is what I want to be given to my wife or to my daughter or to my husband or to my children or to my father or to my mother. This is how I want my property distributed. This is what I own and all of that. There are lots of basics in the will.
So
now,
what then is a
the will. Now, the first instrument is the will. Now, if let's take the first document. The first of that document is the will. Now, let's say 5 years down the line, you amassed. Okay. Let me take it back a bit. You wrote your will in let's say 2016, when you were like maybe 40. And at that time, you had a Mercedes, you had just a bungalow, and you had maybe 5 shares in 6 different companies, and then you had some just minor basic general assets. And then 10 years down the line, you bought 2 properties in Abuja, bought 2 in Lagos, got extra shares, started a new business, and then other things sprang up, got new cars and all of that. Okay, and then some of the Mercedes is no longer working. You have sold it. So that Mercedes that you had given, maybe in the first will, you had given the Mercedes to your wife, and then the bungalow was the only house. You had sold it, and you had bought another house. So that means whoever it was that you gave that bungalow, it is no more available. It's not existent anymore. So now you need to do a codicil. The codicil is like an addition to your will.
Okay.
It is in the codicil that you take care of whatever it is that is not in your will.
Okay.
You are adding to the content of your will. So instead of withdrawing the will, some people say, no, I want you to know. Instead of withdrawing that will, if the content of your will, the basics of it are still intact, you don't need to withdraw it. You do additions, and you do that by a codicil. So that's why if you are doing another thing, it will be your first codicil, because that is your first addition to the will. So now you are now saying that, but by then, if your lawyer is drafting that for you, the lawyer might be saying, okay, in clause this of the will of so and so date, I had stated that the bungalow was given to so and so. So the bungalow has now been sold, and I've now acquired this one, and this 3-bedroom or 1 duplex and so place in Ikeja has now been given. I now bequeath it to my lovely wife or my lovely daughter so and so, and the Mercedes has been sold. I now have a Lexus and a Prado Jeep and all of that. I've now given that to. So you're basically updating the content of that will. Whatever has been sold is now being replaced, and whatever was not there, you are now adding other assets to it. So maybe then were 2 cars, now there are 6 cars. You're distributing. There's 1 property there. There are 4 now. You've bought more shares. Some shares have been sold. You've acquired more. And all of that.
Additional.
They're more like additional property to your will.
So we know what a will is the main document. We know the codicil is any addition you make to the will. So what then is trust?
Okay. When you're talking about the trust, you're talking about a legal arrangement where you are giving your assets or your property for somebody else to manage for you, for the benefit of another person. For instance, maybe you have a child that is not of age, that is less than 21, or maybe that is 18, that is not up to 18, and you feel there are times that maybe you feel, who do I trust that can manage this thing, that can hold this thing in trust for my child or for a parent or for anybody. Some of the instances I've seen are instances where parents are keeping their property in trust, are keeping it in trust with a trust company for the child. It's more like a fiduciary duty to act in the best interest of the beneficiary. And you see it it's usually for maybe estate planning, asset protection, tax planning, because of charitable giving or managing inheritances. Maybe you inherited a property from your parents, and you feel that if this child gets this inheritance at this time, he may not be in a good position to be able to manage it well. So the parents can open a trust fund or a trust for the child, and the trust company acts for the benefits
of the
and the interest of
I think one of the difference or the benefits to a will is that you can begin to see it almost is it reap the fruit, quote unquote?
Yes.
Like you can see it begin
because the person died, because there's always a timeline. They can say, okay, the child does not get a particular amount until he's 21.
Yes.
Some can say when you are 18, you are entitled to maybe 21% or maybe $5,000 or X amount of money. When you are 21, you can now have the whole thing.
Yeah.
You know, there are timelines for trust funds or trusts.
I think the one of the major differences is that whilst a will comes into operation at the death of the person of the will, in your lifetime you can actually see the trust operate even for the benefit
depending
of the
on the kind of trust because there are revocable trusts, there's testamentary trusts. There are some trusts that don't take effect until the person that gave the trust fund is dead. So it depends on the type of trust.
So basically, you look at what is most beneficial to your situation.
Yes, to know which one to apply.
Yes, and that's why we are talking about you actually planning your estate. Yes. Look at everything that you have.
Yes, and that's also why it's good per time. You know, I'm of the firm belief that there are 3 people you need. You need your pastor, you need your doctor, and you need your lawyer. And then the 4th one, you need an accountant.
Yeah.
So I think it's good for you to visit your lawyer from time to time, so that if there are basic plannings you need to do, you know the best that suits you per time. Yeah. Because the type of estate planning that suits you as a single person might not be what you need as a married person, might not be what you need when you have kids, might not be what you need when your children are in secondary school or in high school or when they're university or as grandparents. So it depends on the phase of life that you are in per time.
I want us to quickly go back to not really go back, but we're still talking about the issue of the will.
Okay.
We've had instances where some people have made wills and then it has been contested. What are the things, they'll say it's not legal, the person was... There are so many, I don't want to go into it. I want to talk about it. What are the things that can make a will...
Void. That can invalidate a will.
Yes, because you mentioned that somebody can write a will for themselves. So let's say, for example, somebody is listening now and they want to write their own will. What are the things...
Because they don't want to pay a lawyer.
No, please, that's not the reason though. You must not be listening to this.
They will say, laws are expensive.
No. I want to believe we don't have those kind of people listening to this program, because the idea of you is for you to learn and to put it to practice. It's for you to say, okay, maybe for now I'm just starting small. I've heard the lawyers say I can put some things down, and I just want us to talk a bit about what are some of the things that can make such a will illegal. Some things you should...
Invalid.
Can
invalidate a will.
Invalidates a will. And
void.
Then I want us to talk also about beneficiaries. Particularly I want us to talk about the area of are there specific things you should consider when choosing a beneficiary. So those 2 things.
Let me start from the last. As to beneficiaries, there's no limit to who can benefit. There's no limit to who can benefit in your will, because the choice of beneficiary is always at the mercy or the decision of the testator or testatrix. By testator, I mean a male who is doing a will, and by testatrix, I mean a female who's doing a will. That's the legal terminology for that. So you are the one, that wants a will done. It's the one to decide who you want to be a beneficiary to your will. You can decide, I only want my dogs, I only want my cats, or I only want my mom or my dad.
We've seen instances of where they actually will all
everything to their dog.
Animals.
Yes, so it's not strange. Yeah. So some would say, I only want my children to benefit. Some would say, I don't want my husband, I only want my children to benefit. So the choice of beneficiary is strictly yours. However, you must take note of the fact that there are columns for witnesses. There must be 2 witnesses to your will. and a witness to your will cannot be a beneficiary to your will.
Can you explain that? Let's break that down.
For instance, in every will, a will is supposed to be signed by the testator or testatrix. The Lord mandates that you sign it.
That's the person who is making the will.
Yes, in the presence of two witnesses. So the people witnessing your will cannot be beneficiaries to your will, because your will is supposed to be a secret. So the possibility that they witnessed your will, because they are witnessing to the content of what is in your will. So, and it is supposed to be made known after you are gone. So the tendency that the people that witnessed it, who are beneficiaries, already know the content, and it can cause issues.
Yes.
So it's always best that the witnesses to your will are people that are not benefiting from the will, to save issues of contest tomorrow. That's one other aspect. And then when it comes to choice of executors of your will, the executors of your will can also be beneficiaries of your will. For instance, if you have willed properties to your wife or your children, you can make your wife or your children beneficiaries as well as executors to your will.
So the executors are the people, just the word they execute.
They are the ones that execute, that bring to life, that carry out your desires, your instructions in your will. Now, it's also possible that the people you made executors are not benefiting from your will. There are instances like that. So it's more or less like the people that you believe are in the best position to carry out your wishes and instructions after the person is gone.
So I can say, for example, in an instance where you make a witness the will, a beneficiary is a witness who will make it voidable, will make such a will voidable. You know, we're talking about examples where a will can be voidable, so such can be an instance.
Yes, if the witness to your will is a beneficiary to your will, then that's a ground for invalidity.
Under the law?
Under the law.
Okay. Are there any other grounds?
Instances, there are other aspects that can invalidate a will is if the testator or the testatrix, that's the male or the female who wrote the will, is proven to be of unsound mind. Either mentally or at the time of writing the will, it was proven after the person has died, at the point of contest, that the testator was not of sound mind. Maybe he was ill, his health status was not predicted, was not proved at the time. Then those are loopholes that can invalidate the will, because people that already don't like what you have said in your will might say, okay, they took advantage of your state of health. Yes. So advantage of your state of health to apportion some properties to him or themselves, and to the detriment of other aspects of your decisions or your instructions. So instances like that can come. So that is why most times any lawyer who understands these issues makes sure that at the point of doing your will, some basic ingredients are in place. Things like, if a person is of sound mind, questions like your name, your age, your date of birth, where you are from, where your mother is from, where your father is from, your state.
So long as the person can still recollect.
Basic things from your childhood. That shows the mental state of that person. If the person is married, when he got married, where he got married, the name of the wife, the name of the children, their date of birth. There was an instance of a will I wrote for a 96-year-old woman. She had, I think her husband was late at that time. Her husband had died like 6 years ago. That was like over 10 years ago, before we were doing her will. So when the husband had disinherited someone, so at the time she wanted to toe the same line as well, and we wanted to be sure that there would not be a contest, because we already anticipated that would be a point of contest. So we asked her questions to ascertain her mental state. Asked her full name, she told us her full name. Asked her where she's from, asked her date of birth, where she attended primary school, she answered us. Her secondary school, she answered her university. What was her maiden name? What was her husband's name? When did she get married? What was the color of her wedding dress? Little details that you feel someone of that age may not remember, but she remembered all of that. We included all of that in her will. And then we asked questions. When did you have, she had, I think she had 8 children. We asked her how many children did she had. She named all of them one by one. And we asked her their date of birth. And she could remember their date of birth one after the other. Now, you wouldn't say that somebody like that is not of sound head, sound mind, sound disposing mind. That's the legal terminology. Sound disposing mind. And then we asked questions as to what was the reason for the husband disinheriting that child that she also wants to disinherit 10 years down the line. And she gave us the background, which we included in the will, to give the reason why, because of this, she's also towing the same line.
So I like what you're saying, that, because that was going to be my next question, that can you disinherit someone from your will?
Yes, you can. The property is yours to give to whomever you choose, and not to give to whomever you decide not to. The property is yours. You decide who you give it to and who you don't want to give it to.
The reason why I asked, sometimes there's this concern that people sometimes can be, what's the word, entitled.
Yes.
So you believe that, because...
We're seeing a lot of entitlements in a lot of people these days, especially when you raise children with an entitlement mentality. They grow up with the mindset that everything that the parents have belongs to them. So it doesn't drive them to kind of go out and own their own thing. So there are instances where parents disinherit their children because they might feel, well, this particular child feels entitled and I've done all I can for this child, or all I should for this child in my lifetime. So I think with the basics I've given to him or her, he or she should be able to fend for him or herself. So it's to me, it's not more or less like disinheriting. It's more or less like helping the child stand even after you are gone, by not giving him what the child thinks he's entitled to.
I think it depends on the way, because for that child, if we had someone like that child listening, I think they're just being mean, they're just being wicked. But just like you've explained, there are certain times that parents make certain decisions for your benefit, so that you can actually stand on your own and all of that. Now, what happens if a beneficiary to a will dies before the owner of the will dies? What happens?
Well, if the beneficiary to a will dies before the testator or the testatrix, then there will be a need for a codicil. If you've done a first codicil before the said beneficiary dies, you can do a second codicil and give what you have given to that other person to another person. Now, there's also a second aspect of that. There are clauses. That's why I said it's best for a lawyer to do your will for you. Because when a lawyer is crafting or drafting your will, there are clauses where you say things like, I give this property to this person and this person. In the event that this person predeceases the testator, then this property goes to this person.
So you can make arrangements.
Yes, in the event, not that you are predicting death for the beneficiary, but it's just like a caution. So, but in the event where such was not done, you can always do a second codicil and say that in the first codicil I had given XYZ property to Dele, and Dele is late, and therefore I'm giving this XYZ property to Falano, and if Falano predeceases his children, then the residue of the estate goes to his children, things like that.
Thank you for joining us in this episode of the Settle Law Clinic podcast. We hope you enjoyed the conversation. You can listen to more episodes like this on our YouTube channel or wherever you listen to your podcasts.